Hello everyone, and welcome to the Law for Liberty channel. This is our second video in the California Justice video series. While in our first video we discussed California's multi-felony discount, in this video we're going to talk about a resentencing provision that California passed just for repeat felony offenders. Now, much like California's multi-felony discount, this might be hard to believe at first. However, just like we did in that video, we're going to back up everything we talk about here today with the law. In this case, it's California Penal Code, section 1172.75. However, before we can understand Penal Code section 1172.75, we first have to understand Penal Code section 667.5. Specifically, we have to understand subdivision B. Now, as you can see here, subdivision B is a little long and contains a lot of legal jargon. Rather than combing through this in detail, I'm just going to provide the cliff notes. Essentially, what Penal Code section 667.5b states is that if a defendant is convicted of a new offense that is a felony and they receive a prison sentence, then an additional 1-year term will be added to the sentence for each prior sexually violent offense that they committed or that they served time in prison on within the last 5 years. So, despite the legal jargon, this is actually pretty straightforward. If a defendant commits a felony, such as second-degree robbery, within 5 years of committing a sexually violent offense or being released from prison on a sexually violent offense, then an additional year is imposed to whatever the sentence is on the robbery. If the defendant committed 2 sexually violent offenses within 5 years, then 2 additional years are added to whatever the sentence is for the robbery. Now, you may have wondered why sexually violent offense is highlighted in yellow. And that's because this limitation did not exist prior to January of 2020. Prior to that time, this additional year would apply to any prior felony committed within the last 5 years, not just sexually violent offenses. However, that all changed with SB 136. Passed in 2019, the bill removed the 1-year enhancement for all felonies except those that were sexually violent. That brings us back to Penal Code section 1172.75. As you see in subdivision A, this law takes SB 136's limitation to sexually violent offenses and makes it retroactive. It does so by declaring that every existing 1-year enhancement for a prior felony, except for those few felonies that are sexually violent, are legally invalid. However, the statute doesn't stop there. Subdivision C states that if the court determines that the current judgment includes an enhancement described in subdivision A, the court shall recall and resentence the defendant. As subdivision D goes on to explain, this resentencing must result in a lesser sentence than the one originally imposed as a result of the elimination of the repeal enhancement, unless the court finds by clear and convincing evidence that imposing a lesser sentence would endanger public safety. We'll talk about this public safety exception in a minute, but let's first take a look at this resentencing provision. To do so, it helps to consider an example. Let's imagine that there are 2 defendants, Defendant A and Defendant B. Defendant A was convicted of second-degree robbery, assault with a deadly weapon, and carjacking. Defendant B was only convicted of second-degree robbery. Within 5 years of this felony conviction, Defendant A had been convicted of second-degree robbery, felony domestic violence, and grand theft. Defendant B had no prior felony convictions within 5 years. In fact, this is Defendant B's first felony conviction. Under Penal Code section 1172.75, only Defendant A is entitled to resentencing. Because Defendant D did not commit any felonies within 5 years, he is not entitled to resentencing under the statute. Now, one answer to this unintuitive consequence might be that the resentencing is just removing the additional years added by the 667.5b prison priors. However, as we look at subdivisions D1, D2, and D3, it becomes clear that defendants will receive much more resentencing than the elimination of the 1-year priors. Judges must apply all new changes in the law that can reduce sentences. The courts may also look at post-conviction matters to see if that warrants reducing the sentence as well. In fact, as the California Supreme Court recognized in People v. Rodius, the resentencing of defendants with prior felony convictions may well result in the reduction of the effective length of the defendant's term of incarceration. In Rodius, the Supreme Court held that defendants will be entitled to resentencing even if they're not serving any additional time on the prison prior enhancement. And this is because, as the legislative history makes clear, the legislature was not just intending to remove these prison priors, but was also motivated in a large part by the purpose of reducing incarceration and reducing the public expenditures of overcrowding. Now, turning to our exception for dangers to public safety, the one does state that courts may impose the same sentence if they find by clear and convincing evidence that a lesser sentence would endanger public safety. Notably, clear and convincing evidence is a relatively high standard. It is higher than the preponderance of evidence, or more likely than none, but lower than the beyond a reasonable doubt standard. Notably, at least some case law has found the statute is unconstitutional as it applies to three-strike sentences because it imposes a higher standard in assessing dangerousness than the California voters adopted in the Three Strikes Reform Act. While it is a difficult task to attempt to discern how dangerous a particular inmate is to the public if they are released, and while clear and convincing evidence is a difficult standard to meet, there has been at least one case in which the clear and convincing evidence standard was found satisfied, and the trial court imposed the same sentence at resentencing as was originally imposed. This judgment was affirmed on appeal, leaving hope that this exception can mitigate the chances of dangerous inmates being released under the resentencing statute. While there's much more that can be said on this statute, as well as California resentencing more generally, this is where we'll leave off today for Penal Code Section 1172.75.
Thank you for watching the Law for Liberty California Justice video series. We hope that you enjoyed learning about Penal Code Section 1172.75, California's resentencing law for repeat felony offenders. If you enjoyed this content and would like to see more, please consider supporting our channel by liking and subscribing. Finally, what are your thoughts on this resentencing law? Let us know in the comments below.